Change of persona or change of status?
Now, that would be a change of status.
It's change of status.
If it's just changing the person, no, it's a change of person, yeah.
So it's not a distinction without a difference then.
Okay, let me explain. I don't want to get into an academic debate.
No,
all I was saying is
it's important for us to ensure that we're not blurring conceptual lines.
Yes.
Because otherwise the debate won't progress.
That's exactly.
And at least you and I, at least in this court and from the bar in this court, we should be able to agree at least on first principles.
Yes.
Okay.
Yes, and the first principle I'm merely asserting, really, is that, of course, it would be foolhardy for me to say change of status is synonymous with change of person. That's not what I'm saying.
Okay, sorry, I understood you to be saying that.
Yeah, no.
Okay.
No, then
so when you said it's a distinction without a difference, did I misunderstand?
Can I explain myself?
Yes, sure, please.
I think it would be better that way. So I'm saying the only thing I'm saying really, which is quite simple, is that there are situations where a change of status and a change of person could overlap. And I gave the example, I'm not going to give it again, about when a child comes of age. That's all I'm saying. So I'm saying, if we are still talking at a conceptual level, let us at least accept that the two concepts are not mutually exclusive. That's really the only simple point I'm making. Now, if we move from that, it doesn't mean there are no situations where it's only a change of status and other situations where it's only a change of personality. The only point I'm making is that the two are not mutually exclusive. One. Now, let's come to the second point. The second point is this. Let's leave the conceptual now and come to the point of this case. The confusion which often arises in these cases, particularly to do with the public protector, arises from the following. The term the public protector, and that was the original appellant, if you like, has got two legal meanings. And when we say the public protector is the applicant or appellant, it automatically encompasses two legal concepts, right? The one is the institution called the public protector. The other is the person, the human being, called the public protector. So this is one of those cases which accord with the example I just gave, where a person, if you like, not graduates, transits from the one status to the other, right? Now that confusion is fairly common, but it can be easily explained. If you go to Section 181 of the Constitution, it lists the institutions that, like the Public Protector, the Auditor General, and so on, so-called Chapter 9 institutions. Right. If you go to Section 182 of the Constitution, it then tells you what are the powers and functions of that institution that has just been referred to in Section 181. So that's the public protector qua institution. But if you move on and go to Section 193 of the Constitution, you will find that it's now a different, same appellation now assumes a different meaning because it now attaches to a human being, right? So we must just be able to separate between the institution and the human being. So Section 193 of the Constitution says, how do we know that it's talking about a human being? It says that only in the instance of two of those Chapter 9 institutions, the Auditor General and the Public Protector. Those are the only institutions where what I've just said applies. So if you talk about the others, ICASA and so on, the institution is the institution. So if you say the commission or whatever, you mean the collective, not the human being. But in the case of the Auditor General and the Public Protector, it says the President shall appoint a man or woman to be the Public Protector or the Auditor General. That means now we're now talking about a human being, man or woman, because an institution cannot be a man or woman. So that's the real conceptual confusion that occurs. Now, so which status has been lost? The status that has been lost is for Ms. Mkhwebane as the Public Protector in the Section 193 sense. So all that has simply happened is that, in this case, just because of the removal, it could have been by a fraction of time. The removal is irrelevant to but for whatever reason, she has, while the matter was proceeding, has stopped to occupy the office. And by the way, quite separately, if you go to Section 5 of the Public Protector Act, there's another person that is envisaged. That person is called the Office of the Public Protector. It's not relevant for the present debate, but it also has become a source of unnecessary confusion. And the Office of the Public Protector is, in terms of Section 5 of the Public Protector Act, is a juristic person. So you have three entities, if you like. You have the Public Protector as an institution, Public Protector as a person, and the Office of the Public Protector as a juristic person. All those three can bring proceedings.
So what is the legal consequence of her
of her removal?
Of her removal, of
yes.
not occupying
no longer occupying the office, yes.
Protected.
Yes. It is this, Justice Nicole. It is that she, and that's why we have the Rule 15 notice. It is that she no longer can say, I'm here, let's forget the third, in those two capacities that I mentioned. She can no longer say, I'm here in this capacity.
Which capacity?
That is the representing the institution, the institution, the Section 181 of the Constitution capacity. She cannot do. So that's the first legal consequence, Justice Nicole.
And in which capacity had she litigated throughout?
Well, that's another interesting question. That question was debated in cases such as the Commissioner for SARS versus Public Protector, 2023, Volume 1.
No, in this matter.
No.
I'm not talking about historically. In this matter, in which capacity had she litigated throughout?
In all the capacities.
So I mean, just when you say all the capacities, what do you
okay,
mean?
let me say both, so that I leave the other.
And what are those two? I mean, just let me make a note of exactly what it is. How do you define it?
Okay, let's go through it. Section 181 capacity, let's call it that for shorthand.
And what would that be?
That's the institution.
And if one is litigating in that capacity, how would such a litigant be described on court papers for the purposes of having standing?
Well, you would say, okay, both ways. If she was the applicant, she would say that I'm here as the public protector appointed in terms of Section 181, I suppose. That would be the simplest. In other words, what it would be saying is that, okay, let's say it was an action. It will make it much easier if it's an action. If it's an action, whoever is suing here would say the defendant is the public protector.
No, if she's suing someone, how would she describe
It's
it?
the same. Okay, let's assume she's suing someone. If she was the plaintiff, she would say the plaintiff is the public protector offices at such and such a place in Pretoria. Now, that would be in the one sense. In other words, if somebody damaged the property of the offices of the public protector, that's what the particulars of claim would read like. But if somebody stabbed her, right, then she would say, in the office, let's say, to make it easier, she would say, the plaintiff is either Adv Mkhwebane or the public protector, and now she would be referring to the 193 capacity. So that's a very good question, because it makes it clear.
Why would she do that? I mean, let's just use the analogy of judicial office, for example.
Yes.
If I'm involved in a motor vehicle collision and I sustain injuries,
Right.
and prosecute a claim against the Road Accident Fund, for example,
Yes.
I would be cited in my personal capacity. My occupation would be that of a judge.
No.
But as the plaintiff in that matter, I would be cited in my personal capacity because those are personal injuries that I've sustained.
Yes. No. That's why I put that rider to make it easier to say if that motor accident happened in your office, inside your office, I don't know how that would happen, in the parking lot. Yeah. Then I'm saying you could say yourself, let's say you are now suing the Department of Justice because the accident happened just outside here. You'd say the plaintiff is XYZ, a judge or judge president or whatever the capacity of that person of the High Court. But what I'm trying to explain is that when you do that, that's a completely different thing to if you were going to institute an institutional proceeding for the SCA as such. Okay? So the plaintiff...
And the nature of the proceedings that we are dealing with here,
Right.
I mean, are these institutional proceedings? Is it intended in any way to vindicate rights or obligations that inhere to the office of the public protector?
It's both. That's exactly the point. There are, for example, some of the claims before you are based on Section 10 of the Constitution, human dignity. Another claim is based on Section 34 of the Constitution, the right of everyone to institute proceedings. Those claims are clearly attached to her as a person. So you can't unscramble the egg. The point is that it's your example.
Let's just test that. How would
Yes.
that compare, for example, to a situation, is there any comparison, to a situation where, for example, the public protector has issued a report which is now being challenged?
Yeah, absolutely.
And in those circumstances, I mean, one would imagine that there's a clear dividing line.
Absolutely.
In other words, it would then fall to the office of the public protector to seek to protect the integrity of that office and to protect the work of the office.
No.
Now, is there an analogy between that and this?
No. Okay, you're making two mistakes.
Am I?
Yes. The first one is the
Most
office...
people would say I usually make a lot more than just two mistakes.
No, today is only two. You have a discount. So the first mistake you're making is that, and that's what I was trying to avoid by making this explanation. Once you utter the words, the office of the public protector, you are in another world altogether.
Oh, really?
Yes.
Okay.
Which is Section 5 of the Public Protector Act, which is nothing to do with what we are about here today. So that's wrong. So let's come back to the two that are relevant for today. I was trying to avoid exactly that mistake because many people make that mistake.
Sorry, but before you get
Sorry,
Justice. In her papers,
Yes.
she describes who she is and how she comes to
Yes.
court.
She does.
And it has nothing to do with any one of the two sections, 181 and 192.
It does.
How so? Because she gives a description and she is appointed in terms of section
1 big A.
Protectors Act.
Yes.
She stops there.
No.
She
That's
stops there. What else is she saying? When you look at her notes, sorry, her filing affidavit.
Can I answer now? Right. When she says in her particulars of, in her founding affidavit, that she is appointed in terms of section 1 big A of the Public Protector Act, what is she saying? She's saying that I am not here in the section 181 capacity. Justice Ponen has made a very good example. In other words, I'm not here as I would be here if someone was saying, we don't like your report. Because the report is not hers as a person. The report is for the institution, right? How do we know that? We know that by going to, I'm sorry, I don't know what I did. Yeah. We know that by going to what the founding affidavit is telling you to do, which is go to section 1 big A of the Public Protector Act. And you will see there a miracle.
See a what?
A miracle. Because this division that I made of 181 and 193 is actually verbalized in black and white in that section. So you can't read this and know what she means without actually, after reading this, going to the Public Protector Act, and then this is what it says. Section 181 big A2, which is the same thing as what I just said earlier. The President shall, whenever it becomes necessary, appoint a public protector, right? This is now a person, not an institution. The President doesn't appoint an institution. Appoint a public protector, and here's the part. In accordance with the provisions of section 193 of the Constitution. Okay. So that it can never be clearer than that. That what we are dealing with here, if you actually read page 1 of the founding affidavit, the answer to this, what looks like a conundrum, is very easy, because that section takes you directly. It doesn't take you to section. If she was suing about, as Justice Ponen correctly says, about a report, she would say, the public protector in terms of section 181, which is the question I answered earlier to Justice Ponen. So, I'm sorry.
I just need to get it clear in my head.
Yes.
So she's not here in her capacity as the head of a Chapter 9
No.
institution. She's here as what?
Okay.
In your...
Yes. All right. Okay. Let's take it slowly. So what has happened? If everything that I've just said here, if, let's say, the objection was, which it was, by the way, in the Western Cape High Court, because at that stage she was still the public protector. And the so-called cross-appeal is based on that objection, if you remember. The cross-appeal says, no, she might be cited as a public protector, but she must be mulcted with personal costs because she's here as herself, because she's here to put it simplistically, to protect her labor rights. I'm simplifying.
Well, advancing a personal interest.
Yes, I'm just saying I'm simplifying a complex thing. That's what the entire so-called. So it's that's why these parties, at least.
Well, we'll get to them. But I mean, perhaps you can just deal with that question, because what's tending to happen is we are going down little rabbit holes, and let's try and avoid doing that. The question that was put to you, and I'm going to ask my colleague to repeat the question because I think it's an important one.
I know the question. I was simply, it was not because I didn't hear the question, I was simply giving context to my answer, but let me go straight to the question. So she is here in the same way that she was, she's in here in now 2 other capacities. Certainly she's not here as the public protector because that office is gone. Yeah. That is why if that office had not gone, Justice Nichols, there would have been no need for us to file a Rule 15 application. Maybe that makes it clearer. The only reason that we have filed a Rule 15 application is exactly because she no longer occupies that office. Otherwise, we would have come here. And if one of my colleagues said, well, she must tell us, is she here in 181 or 193?
So is she here in her personal capacity?
Yes.
She's
Yes.
here in her personal capacity.
Has she been throughout before the court in a personal capacity?
Has she?
Throughout the litigation, has she been before the court
if she was throughout the litigation, there would be no need for a Rule 15. You can't say, I'm here, have you always been an executrix, or have you always died?
What is the change of status then?
Yeah, that's exactly what you've just postulated, that she was previously here in her official, in a personal capacity, but as the public protector. All right? She's now here before you as Advocate Adv Mkhwebane. Right? The mere fact that it goes to your example about the accident in the office, you would be suing the RAF as yourself, as a human being, like all of us. But if you are suing the Department of Justice for the whatever claim might lie against them, then you might be suing as a judge or any other official capacity. So if you had those 2 capacities and then you went to the court and they say, are you the one or the other? You would say, well, I'm both. There would be no need to a Rule 15. The very thing that has necessitated Rule 15 is the fact that she hasn't died, thankfully. She hasn't been rehabilitated as an insolvent, thankfully. She has simply changed from being here in that 193 capacity to being here as herself. That's why there's a Rule 15 notice application. That's the whole point of that exercise.
Well, can we just, now that we've got to this point,
right.
Why is Rule 15 applicable in this instance?
Right. Okay. I've already answered that, but let me do it again. Firstly, Rule 15.1 talks about proceedings, and it says whenever.
Is it available to a litigant after judgment?
After judgment?
Yes.
In which court?
In the court below.
Yes.
Why do you say that?
Because, you see, that's the confusion with the case that you gave us in Chambers. Says that...
are you aware of Kader versus Frank? That's a 1926 AD authority. The case of Kader versus Frank.
No.
That's a 1926 AD authority, a judgment by Innes, CJ, who says the following. Mm-hmm. It does not follow, however, that after notice of appeal, they could have claimed to be substituted upon the record for the purposes of defending the appeal. Mm. Now, and consistent with that, the academic writers appear to suggest the following. Harms, for example, says it's doubtful whether the rules applies to a situation after the grant of judgment, and an application to court may be necessary where it is desired to substitute a party after judgment has been given. Erasmus puts it more strongly, saying, in view of the proviso, application to court will be necessary where it is desired to substitute a party after judgment is given.
Yes, but okay, that's another... the answer to that is also very simple.
And that is actually endorsed That approach, the approach by Erasmus, is actually endorsed in the authority that I'd sent to, that I'd favoured counsel with this morning in Chambers.
No, it is not. Let me explain. When you talk about proceedings in the context of Rule 15,
yes,
right? Here, you are talking about these proceedings. The confusion.
Talking about the appeal.
Pardon? Yes,
We're
these
talking about the
proceedings.
appeal.
Yes.
Now, why do the uniform rules apply in this court?
Because this court has.
Doesn't the SCA have its own rules?
No, it does, but that's the Justice Ponan. You know, we're here about a court that the previous court, at least, took a technicality out of a very serious situation. So now,
Sorry, what is that supposed to mean?
no, I'm saying that what we're debating now, as I said, I'll start with the technical.
Well, it is technical because substitution
Yes.
of parties is a technical matter.
Yes, that's what it means.
And,
Yeah.
and it's got to be conceptually correct.
No, I know.
Yes.
But I thought you were questioning whether it's technical or not.
Yeah.
That's what I mean. Yeah. So I'm saying that the technical. In fact, this, with the greatest respect, is even worse than what the Western Cape Court did. Because what we're now saying is that we want to non-suit a person who has come to court simply because, imagine, if this were correct, you would non-suit someone whose constitutional rights have been violated because, why? If we ask, no, because Rule 15 doesn't apply to the Supreme Court of Appeal.
Well, if Rule 15 doesn't apply, you could have applied to court a proper application supported by affidavit, in which event, if the other side was going to suffer any prejudice, they could have opposed the application, raised the prejudice, and the court could have ruled on it.
Yes.
So it's not like she would have been entirely remediless.
No.
She would not have been without a remedy.
No, Justice Panan, your first question is the correct one, because, as you know, the entire purpose of Rule 15 was to do away with the necessity before in 1926 or whenever in a situation.
In appropriate circumstances, Mr. Mpofu, and I mean, if you look at, and that's been consistent with the authorities of this court. The first question you've got to ask is whether or not Rule 15 applies in a given situation.
Yes, but
If it does, you invoke Rule 15 and you comply with it.
Yes.
But if Rule 15 doesn't apply, and look at how we got to this point. We got to this point because one of the respondents wrote to the current incumbent of the office, wrote to the Office of the Public Protector to say, are you aware that this appeal is being prosecuted ostensibly in your name? The response that elicited was, actually, it's not happening in our name.
Which is true.
Okay. Then, what they then did was, they raised questions as to the authority of the attorney to act. And in response to that, a Rule 15 notice was filed.
Okay.
Am I wrong? If you say no, am I wrong?
Half wrong.
Okay.
Obviously, you're right that that's what happened. But
I mean, I'm going by the correspondence, not anything that you may be saying from the bar, but I'm going by the documents that have been filed on record in this matter.
so am I, with respect.
Okay, so if you want to point me to something which indicates why I'm wrong, perhaps we can start there.
Okay. Can I start?
Would you want to point me to something which indicates why I'm half wrong?
No. Can I do it by a shortcut? I'll come to that, believe me. Can I just give you a shortcut? Rule 15, this court has applied Rule 15, right? And this court, when it applied, not in 1926, it might have been different because that time the Rule 15 did not exist. The reason Rule 15 was introduced was exactly to do away with what you are saying, Justice Conan, which is the need to do an application, an affidavit, and so on. That's the reason why Rule 15 is there. And this court, in the judgment of Murray N.O. versus Maposa, in which one of the judges was Justice Nichols, fortunately. It's reported at 2020-5, SA 111, SCA. A judgment delivered by this court on the 25th of March 2020. This is what this court said, unanimously, per Plasket JA. Paragraph 5. Rule 15.1 of the Uniform Rules of Court provides that proceedings do not terminate solely because of the quote, death, marriage, or other change of status of a party, unless such proceedings is thereby extinguished. Rule 15.3, and then it goes on. And then at paragraph 11, let's start with paragraph 9. It says that, I would have expected the respondent, to have agreed to be substituted as an appellant without hesitation. And then here's paragraph 11, which is important. The court said, I am satisfied that Mr. Murray ought to be substituted as an appellant in terms of Rule 15. Okay? That passed, the last three words I added because of paragraph 5. I also take the view that despite his unacceptable abdication of his duty as an executor, which was relevant to that case, Mr. Shongwe should be substituted as appellant too. The opposition, to my learned friend's credit, there's no opposition here. The opposition to what?
Because there is no application to which there could be an opposition.
Well, but they're here. If there was an application, they wouldn't be here.
No, I say there is no application to which there could be an opposition. All you did was you filed a notice in terms of Rule 15. And that's what we're debating.
Okay. Let me read, I'll come back to the SCA case. Let me read what Erasmus says about this. The purpose of Rule 15 was not to afford the High Court the power to substitute a party to proceedings. It already had and still has that inherent power in terms of Section 173 of the Constitution. Under the common law, when the rule was introduced, the rule is designed to simplify the procedure where a party to proceedings has undergone a change in status. Previously, when a party died, married, or became insolvent, attained majority, was placed under curatorship, and so on, it was necessary to apply. Right? So the rule is intended exactly to do away with the application you are talking about. At least according to Erasmus.
No, the authority of this court in Techmed.
In Techmed?
Techmed, yes.
Yeah.
Clearly indicates that there are instances where Rule 15 will not apply. And in that event, a substantive application is necessary.
No, of course.
Do you accept that?
No.
Okay.
I mean, that goes without saying.
Yeah.
That goes without... That's the whole point. The law used to be like this. In every instance, you had to apply for substitution, right? Then comes the introduction of Rule 15, which says in these instances, you don't have to apply. That's all I'm saying. I'm not saying every instance under the sun. Okay. That's not what Rule 15 did. It did away with the need to do an application in situations such as the one that we're dealing with and such as the one that in Maposa was. Remember, your question was, does Rule 15 apply to this court? And I'm saying this court applied it as about 4 years ago, in 2020, unanimously. We'll come to TechMed just now. This court applied it in. I've now lost my place. I'm sorry. In Maposa, and I was when Justice Bonan came in, I was still reading this. It says.
Sorry, Mr. Mkhwebane, does Murray Maposa
also helping because there it was the substitution of an executive. So it was squarely within the ambit of Rule 15.
Okay. Just, can I please beg you, Justice Tipena, I'll come to that question just now. Can I finish? Because otherwise, I'm never going to finish reading this paragraph. It says, because this is also important and it covers what you say. The opposition, as I said, there's no opposition here, to what ought to have been a formality was unreasonable. In other words, the other side for opposing the Rule 15 application was criticized by the court. With the result that Ms. Maposa and Ms. Lidwaba must bear the cost of the application, while Siepent, whatever. Anyway, so the point is the matter is that what the court was saying there is what I've been saying. To oppose an application or notice, which is a substitute for an application in these situations, where, as you correctly say, Justice Tipena, the matter fell squarely within the rule, was unreasonable, which is true. That's why this court said unanimously. But now let me come to your question. There is no difference, unless if we just want to nitpick and say, okay, this one it was an executor, this one it was an insolvent, this one
that's a change of status. I mean, that's not nitpicking. That's our law has always operated on that basis.
Okay, can I answer the question?
Your client has been around throughout. She's not suffered any recent disability, has she, which has resulted in a change of status?
Can I answer Justice Tipena's question, maybe?
Yeah.
Right. So, Justice Tipena, that this matter here, in our respectful submission, also falls squarely in Rule 15. And let me explain Rule 15.1. Let me explain how. When, as we all know as lawyers, when you have that catch-all, I can't remember the Latin phrase, but when you have that catch-all phrase at the end, I think it's called the eius dem generis rule. Yeah. So what does Rule 15.1 say? It says, whenever arisen by death, tick, marriage, tick, and other change of status. Now, what we're saying is that the catch-all phrase, other change of status, means things that are not death, are not executrix, are not marriage, right? So, in other words, the writers of statutes or rules cannot or are not expected to list every conceivable instance. So the phrase "and other change of status" means that there's no distinction between the Maposa situation and this one. Thank you. Now let's come back to I'm sorry, just a second. All right.
Basically, your argument in a nutshell, if I understand it.
Right.
Correct me if I'm wrong.
Yes, just.
She's not the head of a Chapter 9
No,
institution.
she's not.
So she's now instituting, or she's now before us in a personal capacity.
Absolutely.
Like any other person in the
Yes.
street.
Advocate Adv Mkhwebane. Yeah.
Yes. Therefore, Rule 51 applies to her
Yes.
because she's had a change of state.
Yes.
And we must make of it what we will.
Absolutely.
But that's your case.
That's the case, and it's really based on the following. And Justice Nichols, I'm sorry to repeat myself, but the point of the matter is that had that change of status not occurred, there would have been no need for us to do a Rule 15.1, which is not opposed, by the way, by the other side. And to go back to Justice Pondan's postulation, you must look the mere purpose of Rule 15. You must look at that notice. In fact, don't even call it a notice; call it an application, Because that's what Rule 15 sought to do away with the need for us. If there was no Rule 15, we would have had to put an affidavit and say, hereby, please, because I was removed on such and such a date, and so on and so on and so on, and the other side would have made a decision whether to oppose or not. But Rule 15 has been put there to ensure that we don't have to do that. It's the same as it is said in TechMed. TechMed is the case that Justice Ponen has said. At paragraph, I think it's paragraph 14 of TechMed. Yes. At paragraph 14 of TechMed, let me just give the citation. TechMed is TechMed Pty Limited versus and others versus NISHO, NISSHO, EY Corporation and so on. And it's 2011, bracket 1, SA 35, SCA. This is what is said at paragraph 15 of that judgment. As I see it, this focus should therefore immediately be directed at the substitution application, which is where we are now. The settled approach in matters of this kind follows the considerations in applications for amendments of pleadings. Broadly stated, it means that in the absence of any prejudice to the other side, these applications are usually granted. Now, that was a judgment of this court by Brandt J.A., sitting with Arams D.P. and Malan J.A. Right? What does that mean in simple English? What it means is that Rule 15 must be looked at a philosophical level as in the same way as we look at Rule 28. Rule 28 was introduced to say, look, I can give you a notice of amendment. If you don't oppose it, then it's in, right? I will only be called upon to put an application if you oppose it. So that's the simple purpose of Rule 15. It was to do our, that's what Justice Brandt was trying to explain. That you, just as in the case of amendments, firstly, it's a facility, but secondly, it should be granted, quite frankly, unless if there's a serious opposition, which there isn't here. And we move on with the case. That's really what so this court has twice. Firstly, in TechMed, it has said that, and then in Maposa, it has actually followed its own advice by applying Rule 15.
Can I ask you, I mean, how is one supposed to construe the proviso?
Pardon?
How is one supposed to construe the proviso?
The proviso in Rule 15.2.
In Rule 15?
2.
1.
Okay, well, I'm not aware.
Sorry, 15.2.
Yeah, I thought maybe I didn't know the rule. Yeah. No, the proviso is in Rule 15.2. Thank you.
In Rule 15.2.
Yes. No, okay. This is how you read the proviso in 15.2. You have to first understand what is meant by in 15.1 by proceedings, where it says any proceedings. Now, again, this is another common mistake.
Well, it says no such notice shall be given, and that's the notice that we are debating.
Yes, the application
shall
notice.
Be given. No, it's just the notice. It's not an application. It's just a notice. No such notice shall be given after the commencement of the hearing of any opposed matter. How are we to construe that?
Okay, simple again. Firstly, and again, I'm sorry, I'll answer. Firstly, this application is not opposed. But second,
well, I keep saying we're not talking about, we're confusing concepts, and it's important to get terminology right. This is not an application. All you did was you just served a notice in terms of Rule 15, which, if Rule 15 applies, would be perfectly permissible.
No, but it's the same.
So it's not the same.
It's an application, Justice Bonner.
No, with respect, it isn't
the same as a Rule 28 amendment
with
application.
respect, it is not. All you've done is you've served a notice. Now, can we just debate the proviso? Because I think terminology is important.
Yeah, but
And because what happens is if we get terminology wrong, that's where conceptual confusion starts to creep in.
yes,
Now, how do you say this? And I pointed you to the 1936 judgment.
1926.
Yeah, the 1926 judgment earlier. But how do you say? How is that in any way inconsistent with what's contained in the proviso?
Okay. You see, the problem is that I can't explain the terminological problems if I can't speak.
Yeah.
I'm still saying, I'm in the middle of addressing your exact question.
Yes.
So if I'm allowed to speak, I
Of
will.
course you are allowed to
yes,
speak.
Okay,
Yes.
good. Now, the proviso in 15.2
Yes.
applies, how it applies to these proceedings, Justice Ponan, is that we cannot bring the Rule 15.2, the Rule 15.1 notice before after the hearing, after this hearing, okay?
After which hearing? Sorry.
This one. Okay, so that's what I was explaining. The conceptual mistake is to think that rule, that 15.2 talks about the Western Cape. No, it talks about here. Okay, so
No, well, let's just start with.
yes,
If there had been a change of status during the course of the hearing in the court below.
in Cape Town.
In the court below.
Yes,
If there had been a change of status before that court,
right.
at what stage of the proceedings would Rule 15 apply, and at what stage would it not apply?
Okay,
So at what stage before the High Court, now forget about on appeal,
Yeah.
at what stage before the High Court could one merely by notice in terms of Rule 15 signify a change of state, a substitution of parties?
good. Now, to answer that question and try to kill two birds with one stone to save time, let's differentiate between Cape Town and Bloemfontein. So in Cape Town, to answer the question from a Cape Town point of view, the stage at which the notice would have been invoked would have been at the beginning, right? In other words, if we stood up there on day one, I think it was a 3-day hearing, and said, my ladies, and it was 3 lady judges, my ladies, we are bringing a 15.1, then the proviso would apply. Forget Cape Town, let's throw it away. Now come to Bloemfontein.
No, sorry. At what stage of that proceedings?
I've just said, as we stood up,
Yes.
right? Like that means literally at the beginning.
Yes.
Okay, so that because of the proviso, that's when we would raise it. And then I'm saying, let's...
So at that stage, would it still have been permissible to merely just file a notice in terms of Rule 15?
Yes, if it was at the beginning, it was before the hearing.
Yeah. Now, when I'm trying to get the dividing line, I mean, the proviso creates a clear demarcation in terms of process and procedural steps.
Okay.
And it's not as if one can just sort of pass over that, because it's an important differentiation.
No. It's okay. Okay, let me explain it. It's not the proviso. It doesn't bring any miraculous dividing line. It simply says that if it was in Cape Town, no such notice shall be given after the commencement of the hearing of any opposed matter. Okay.
Yes.
The commencement of the hearing means the day when we stand up and say, I appear for so and so and so and so.
Okay.
So after that point, you may not give a notice in terms of 15.1. That's all it says. That's really, it's that simple.
Okay.
So that's what it means, and that's the answer. That's why I thought I'm using it graphically to say that when we stand up, that's the point. Okay. Here, forget about Cape Town now. Here in Bloemfontein, you also may not give the Rule 15 notice until the day of the hearing, which is today.
No, of any opposed.
Yes, the opposed proceedings here now is the appeal. So all the proviso says is that if we came here and did this appeal, and then sometime after the hearing we say to you, here's the Rule 15, then the provisor would hit us. But we did this, I don't know when, 6 months ago, whenever we did it. So the provisor has got absolutely nothing to do with the present situation. All right. Right. Now, so so if we could have done it yesterday, for all I care, and it would still be in, the provisor would not apply. Right? Right. So but there are, I don't want to waste more time on this, but the TechMed we've already discussed. Black Sash, which is another case, makes it even easy. Okay, I'm going to address something which, no, let me leave it, because I think it will just provoke unnecessary debate here. But the other way to look at this is as joinder. So you can also look at it from that way. You can look at it as an amendment. By the way, you can bring a substitution application by way of Rule 28, just to emphasize the point in TechMed. And if you go to Erasmus, I think my junior's Erasmus might be dated. So, but if you go to the discussion of Rule 28 in Erasmus, on this version, which I'm not prepared to vouch for, it's D1-339 of Erasmus. So I can just say or thereabouts. If this is the 2020 iteration of Erasmus, yeah. You'll see it tells you the situations, and one of the situations says on appeal, that's under M. Then it explains what happens, and then under N it says substitution of parties. So that's a discussion of the substitution of parties under Rule 28 now, because it can also be done not only under Rule 15, but also under Rule 28. But that's just as an aside. Yeah. Yes. The point I'm really making is this. You can look at a substitution from the prism of Rule 15, you can look at it from a prism of Rule 28, or you can even look at it from the prism of Rule 10, which is the joiner. So notionally, you say you are now joining Advocate Mkhwebane as a party. In Black Sash, and I think it's paragraph 4 of Black Sash, and I'll deal with Black Sash when I deal with the so-called cross appeal. What it says is that in situations where you're going to want personal costs, which is why, by the way, and I must commend my learned friends for not opposing the substitution application, because they would be speaking with both sides of their mouth. They can't say, on the one hand, she must be mulcted with personal costs, on the other hand, they say she must not be here.
Well, I thought that would probably be an argument they will advance against you.
No, you're thinking wrong.
Yes, okay.
Because if they do that, then they're going to be self-contradicting, because they'll be saying to this court, mulct some person in the street with personal costs, but don't allow them in here. What is that? So, that's exactly why, as I say, to their credit, they did not oppose the 15-1 because they were hoping for a bigger price, that they will get the personal costs. But all that aside, the simple point is really this, that you have before you an unopposed Rule 15 notice, which substitutes...
Did the notice make provision for opposition?
Pardon?
Did the Rule 15 notice make provision for opposition?
Well, I don't know, but all opposition, there's no application in court or notice that cannot be opposed. I've never heard of such a thing.
No, I say, did the notice make provision for opposition?
Oh, the note, I'm so sorry. I thought you were saying the rule. I'm sorry, Justice Pona. Well, a notice in Form 1 of the notices, you have two types of notices. A notice Form 2 Form 2 is where you say...
No, I'm saying that this particular notice...
No, it's a Form 1. Form 1 notice.
Yeah, so I'm saying that this particular notice make provision for opposition.
No, it didn't,
I'm not talking about generically, I'm talking about this particular notice.
No, but
Okay,
I'm explaining to you the reason why it
Okay.
did not do so. Because it's a Form 1, not a Form 2 notice. That's the only reason. But the mere fact that you give a Form 1 notice, a Rule 28.1 notice for amendment is also a Form 1 notice. But that doesn't mean a party may not oppose. All right? So so I can assure you, my learned friends did not oppose this because the notice doesn't give them an opportunity. They did not oppose it because they don't want to.
We listened to their submissions in due course.
Well, I don't know what submissions they're going to make because they did not oppose the matter.
Yes.
This application, at least. This application I'm arguing now is unopposed. Let's just get that one out of the way. So it's an unopposed application in terms of Rule 15.1. So no one has anything to say.
Is there anything else you've got to say on Rule 15?
No,
15
no.
Before we move on to the next...
To the next hurdle, yes.
Yeah. Okay.
No.
Well,
There's a lot,
but
there's no time. Yeah.
Let's talk about mootness then.
All right. Sorry. Let me just see if I'm not leaving any... I'm sorry, Justice. Okay, I'll deal with it in the reply if necessary. Let's, for the sake of saving time, then come to the issue of mootness. As I said, mootness. Firstly, this one definitely overlaps with the merits of this appeal. The first one is arguable if it overlaps, but this one certainly does. Why do I say so? Because, as I say, this appeal is about a finding of ripeness. Let's forget the Latin, in medias res and whatever. What that thing is called is ripeness or prematurity. That's simple what it is. And ripeness is a corollary of mootness. The Constitutional Court has said that many times. So the issue of mootness arises, therefore, in two incarnations. As at least as raised by the other side, it arises on the merits, quote unquote, of the appeal. So if the court allows me, I will deal with it in that fashion. May I?
Well, no, I think the primary argument that's been raised is that whatever the outcome of this appeal,
yes,
it won't have any practical effect or result as contemplated in the Act, the Superior Courts Act, because it's been overtaken by a series of events. There are a string of subsequent decisions that have not been challenged, and so those decisions stand. And therefore, even if we were to be with you on the merits of the appeal, and we were to overturn the decision of the court below,
to the academic.
Even on the limited aspect on which it was decided, because it's been overtaken by these series of events, there would be no practical effect or result, as I say.
Yes.
Yeah.
Now, I know what mootness is. I'm simply asking whether I can address it in the way that it has been raised, which is that what the summary you've made, Justice Bonan, is raised as a, if you like, a defense to the merits.
Sorry, I don't follow that. I mean, this is
okay.
You know, because
fine.
Because unless one gets past this obstacle, so to speak, unless one overcomes this hurdle, well, then one is not into the substantive merits of the appeal.
All right. Okay, fine. Let's do it that way. We'll do the long way. So 16, if you do it that way, then we have to look at it from the point of view of of section 16(2)(a) of the Superior Courts Act. It really amounts to the same thing because the test is the same. It says that if the judgment doesn't have a practical effect, and Justice Ponan has correctly summarized what that means, then, of course, the appeal is moot. So that's the first leg. The leg that came from all the line of cases from Van Wyk, Langeberg, Magidiwana, and so on. So those two legs go something like this. If you find I'm saying this because in my respectful submission, this inquiry will end on leg 1. But if for some strange reason I'm wrong on leg 1, then you have to go to leg 2, which is that whether, assuming now that the appeal is moot, whether you should not nevertheless hear it in the interest of justice. And I want to emphasize this. My submission is that you're not even going to have to need leg number 2. Okay, so let's come to the practical effect. How can anyone say that somebody, Advocate Mkhwebane, says, I have suffered multiple violations of my constitutional rights at the hands of these respondents. As a result of that, I had to go through an illegal process. I can't find a polite way of putting it. I had to go through an illegal process.
Illegitimate, perhaps.
Illegal, I think, is better. An illegal process which violated my Audi rules, which violated Nemo Udex, which violated everything under the sun. Yes. No, yes. Under Audi, yes. My junior correctly highlights the real issue, which is the denial of legal representation. So she says to a court of law, I went, let's say, to the magistrate court in Randburg. I'm exaggerating for effect. And the magistrate locked the door and told my lawyers, you're not going to get in here. And she comes to a court of law to say, I want to vindicate the Constitution and my rights regarding that. And she can be told it has no practical effect. That is not our law. Our law is the exact opposite of that. And it is that if a citizen of this country, at the hands of a public institution at that, has his or her rights, human rights, fundamentally entrenched in Chapter 2 of the Constitution, limited, infringed, violated, breached, whichever word you like. That on its own has practical effect. What is the practical effect? The practical effect goes back to what was said in 1996 in the case of Forze, which Forze versus Minister of Police, which, by the way, is the first case I ever argued in front of the Constitutional Court. And in that court, it was the following principle was established by Justice Ackerman, but more by Justice Krechler. That what was meant in the old, interim constitution, it was called appropriate relief. But what was meant by that is that the vindication of the Constitution itself is actionable. Which, by the way, goes to the difference between a declarator in terms of Section 8 of PAJA, which we'll talk about later, a declarator in terms of Section 38 of the Constitution, and a declarator in terms of Section 172(1)(a, which is what we're talking about here. So a declarator that is in terms of Section 172(1)(a is in a class of its own, and it should never be confused with these things of mootness and the delay rule and all that kind of thing. The Gijima principle, which is what I was talking about, says a court of law should do exactly the opposite of what I'm being asked to explain now. It says that when a court is in a situation where the vindication of rights in terms of Section 172(1)(a is at stake, that court, in the case of Gijima, it's actually, and that's why there's been a transient academic criticism, but unfortunately it's the law. But it says the following, that even in a situation where you cannot explain the delay, the undue delay, the court must overlook that and vindicate the Constitution. Right? Now, that principle was debated at length, and one of the judgments, I just forget the name, I'll find it now. Justice Nichols was dissented with Justice Jafta in the Constitutional Court on the application of this principle. But the best articulation of the Gijima principle you will find in the case called Asla, Buffalo City Municipality. Asla Construction, yes. The court knows, if the court just allows me, just change. Before I go to Asla, let me just say this, just to piggyback on what my Leonard Jr. was whispering here. Remember that impeachment, part of this illegal process I was talking about, resulted in her impeachment. But whether it did or didn't, really, quite frankly, is irrelevant for the point that I'm going to make. Because even if she was acquitted at the Section 194 committee, she would still be here to vindicate her constitutional rights, which were, to say violated is an understatement.
But what order would she be seeking?
She would be seeking, you see, that's exactly the point. She would be seeking an order in terms of 172(1)(a). 172(1)(a) has been said from a long line of cases, for Nkandla case, all these cases, that must not be mistaken with the declarator where you are dealing with mere private rights.
No. I mean, it's important for us, again, not to confuse concepts. Okay?
It is very important.
Because an appeal lies against substantive order of the court below.
Yes.
Not the reasoning.
Yes.
And much of your submissions are actually targeted in a more generalized sense against reasoning.
No, it's not.
Well, let's look at the order that was sought in the court below, and let's see how much of that would still have any practical effect.
Right. Okay, let's go. That will be volume 1. Yes, I've got it.
Right. So, these decisions in paragraph 2.
Right.
If those decisions were to issue now.
Sorry, just I'm listening, sorry, Justice. I just want to find my notes here. Yes.
In other words, if this court were to substitute the order of the court below with one granting any of this relief, why would that be an order that would have practical effect going into the future?
You are at paragraph 2.
Well, all of the relief that was sought in the court below.
No. All right. Okay. At paragraph 2, the declarators that are sought at paragraph 2
Yes.
address what I've just explained here now in great detail. So she says, I want this court to declare that those decisions to dismiss the recusal application and so on and so on
Yes.
must be
All these decisions that were taken in October 2022.
yes, are unconstitutional and invalid, right? Now, that's a archetypal section 172(1)(a). It might be other things, but what I'm saying now is that that is a 172(1)(a) order, such as was envisaged in Gijima and Asla, right? So, a declarator of this is the point. 172(1)(a) does not deal with private rights per se. It deals with the violation of the Constitution of the Republic of South Africa as a whole.
So you're saying that we should grant these orders in order to vindicate her constitutional rights to dignity and various things, irrespective of whether it would have any impact on her subsequent impeachment.
Yes.
Is that?
Yes. No, except for that last part. I'll explain why. I'm saying Justice Nichols, and that's why I was making it clear. And maybe your formulation is actually correct. When I say irrespective, I mean, that's why I was saying to Justice Ponan, assume she had been found not guilty in the Section 194 committee. That makes it much clearer. I'm saying, even if she was found not guilty, she has a right under Section 172(1)(a) to come here and say, my rights, the locking out of my legal representatives, in my exaggerated example, the fact that the panel that sat there included somebody who's married to the complainant. You can list, all those things. I don't have to go through of them. There are about 17 of them. Those things amount, as she has pleaded, to the violation of my Section 10 rights and my Section 34 rights. How are the Section 34 rights implicated? Because Section 34 of the Constitution says that you have a right to present before a fair tribunal, forget a court now, before a court or a tribunal. So those two rights at a minimum of mine have been vindicated. And you must, the Constitution says, must. You must hear that, make those declarations.
I understand that.
Yes.
Why are you saying that's not irrespective of the outcome? Because it's
No.
irrespective of the outcome. She says we must vindicate her rights. And
Yes.
it doesn't matter what the...
That's exactly what that's all I'm trying to say.
Okay,
Thank you.
got you.
That's all I'm trying to say. I'm saying you have a duty. It's not it's not may, as in 172(1)(b). You must.
We've got to vindicate
You have
her
no
rights.
option in the
Yes,
matter.
I hear you. And it doesn't matter whether she's impeached, not impeached, whatever. I get
Yes.
your argument.
That's the Gijima principle. The Gijima principle says that in Mkhwebane CJ in the Nkandla case explained it, I think it's paragraph 113 or 103, where he says, sorry.
If you're going to be moving on to going to be moving on, I'm just looking at the clock.
Okay, can you just give me 1 minute? So
Yes,
that-
I was going to say I'll be guided by you, and when
Yes,
we
yes,
reach a
thank-
convenient point
Yes.
in your address to us, just bear in mind that we would be taking the short adjournment
No, thank you very much.
at your convenience.
Thank you, Justice. I won't be long. I just want to break at a natural point here. No. Let me then, because this submission is key to this entire appeal, by the way. That's why I was saying, I was trying to say, you cannot apply the wrong test as the Kota Court did. Because if you miss, in fairness to that court, They frankly admitted it. If you look at the judgment of the application for leave to appeal, they say we simply did not address the issue of the declarators, in all fairness to them. But I'm saying you cannot do that because you are leaving out an entire cause of action which has a life of its own, unlike all the other pleaded alternatives. And if you allow me just to say this, because again this simplifies it, and it might be easier maybe to say this before we go to the break. This is the kind of thing that we teach to pupils. The reason why you plead in the alternative in the first place is so that if you lose cause of action A, then the court must go to cause of action B. Basics. Nobody can quibble with that. What this court did, which is unforgivable, was to say, you lose cause of action A, but we're not going to look at cause of action B. Who does that? Because that confuses the entire judicial function, which is to say, if you are wrong with your cause of action A, and for the purposes of this, I'm not abandoning it, assume we had to lose the review leg. Then the court was enjoined to then say, okay, let's now go to the cause of... This court failed to do that. That's what's wrong with this picture. As God pleases.
We'll adjourn for 15 minutes.